relationship between Mr. Neuman and Melanie White was one of friendship and confidence. That in the time period the state is referencing, the summer and fall of 2010, the two were in consistent communication, that Mr. Neuman considered her one of his best friends. They communicated frequently, consistently via text, phone, and in-person meetings, and that he confided in Ms. White about his personal life. And when I'm referring to his personal life, I'm referring to the marital problems he had going on, the financial problems he had going on, and in particular the relationship he was having with Andrea Sneiderman. The state seeks to introduce Mr. Neuman's statements through Ms. White to the jury that we are picking on Monday. The reason why the state seeks to introduce the reason why it is permissible, I'll refer the court again to the new OCGA 248807. That provides that a statement not specifically covered by a hearsay exception spelled out in Rule 803 or 804, but that has equivalent guarantees of trustworthiness, shall not be excluded. The term of the statute is shall not be excluded if it is, 1, offered as evidence of material fact, 2, is more probative on that point that can be procured through reasonable efforts, and 3, the admission would serve the general purpose of the rules of evidence and interests of justice. The state believes it meets all 3 of the requisite standards, and that the testimony of Ms. White should be admitted. The substance of the testimony, now that I've described the relationship between them, the substance of the testimony are details, some intimate and some particularly graphic, details of the romantic relationship that Mr. Neuman and Ms. Sneiderman had in the summer and the fall of 2010. Mr. Neuman confided to Ms. White, and Ms. White would recount, and did recount at the Neuman trial, and would recount again the particular details that Mr. Neuman shared with her about the relationship, about trips they took together, about things they did together on the trips, their physical relationship, the difficulty and the conflict that Ms. Sneiderman expressed to Mr. Neuman about her continued participation in the relationship and how she always came back. The relationship itself, the framework of that, is admissible, and the state expects that there will be a lot of information about the relationship between Mr. Neuman and Ms. Sneiderman presented from witnesses other than Ms. White throughout the course of the upcoming trial. However, the details that Ms. White provides from the statements conveyed to her by Mr. Neuman are material, they're probative, and they meet the standard of the particularized guarantees of trustworthiness that is required under the law. It is material. The testimony of Ms. White, the previous testimony, was attached to the motion, so the court may refer to that for more details than what I am providing. I also provided to the court and to the defense in the motion a copy of an email chain between the two, Mr. Neuman and Ms. Sneiderman, that was forwarded to Ms. White. She testified about in the previous trial. The evidence is offered on a material fact, the relationship between Mr. Neuman and Ms. White. It is more probative on that point that can be procured through reasonable efforts. Mr. Neuman is unavailable, and the defendant herself cannot be compelled to testify. And so the details that Ms. White has and can share are more probative on this point that can be procured through other reasonable efforts. And the admission would serve the general purpose of the rules of evidence and the interests of justice. The relationship as it's described is going to be a point, I believe, of contention. And while the state can establish the framework and can establish the relationship and can establish multiple aspects of the relationship, there are things that Ms. White and Ms. White only can provide. I'm going to hand the court and to the defense several cases. One is United States versus Rodriguez. It is at 218 F. 3rd 1243. It's a 2000 case.
You may approve.
Thank you, Your Honor.
Thank you.
And Rodriguez identifies to the points the requisite elements that I've described about the residual exception, Rule 807. I'm also going to hand the court two other cases. One is Culmer versus State, C-U-L-M-E-R versus the State. It's 282 Georgia 330, 2007 case. The other is Miller versus the state. It's at 283 Georgia 658. The cases Miller and Comer that I'm handing, they are cases that were decided, may I approach?
Right.
Under what I describe as the analogous old case law, the necessity exception to the hearsay rule that used to be in effect in Georgia. And I'm not giving it to the court, not providing it to the court for any reason other than the language of the necessity exception was the circumstantial guarantees of trustworthiness, the particularized guarantees of trustworthiness. The language tracks what the Rule 807 seeks to do, and so I'm providing those cases to the court for recent examples of what the Georgia Supreme Court has found to be particularized guarantees of trustworthiness. In Comer and in Miller, a situation like what is facing the court now, where there was a relationship between two individuals, one non-available for trial and the state seeking to introduce hearsay statements through someone close to that person. The relationship was close. The details were there. And it is Miller in particular, Your Honor, where the other statements, the hearsay statements, were corroborated in large part by other evidence. I want to focus on that for a moment because that bolsters the state's argument that there is, in fact, particularized guarantees of trustworthiness in the statements Ms. White would relate to the jury. Ms. White describes having constant or frequent phone contact with Mr. Neuman. That's corroborated by other phone records that would be introduced at trial. She describes Mr. Neuman telling her about frequent trips he took with Ms. Sneiderman. They went to London together. They went to Greenville together, Greenville, South Carolina. They took other trips together. That's all verified and documented and will be presented through other witnesses. You can believe what Ms. White says Mr. Neuman said because of other evidence. You can believe what Mr. Neuman told Ms. White because of other evidence, other corroborating evidence. He describes a situation where the two, Ms. Sneiderman and Mr. Neuman, would go on trips together, that they would have a physical relationship while they were gone, that there was a romantic and a physical relationship between the two of them, and then when they returned home, she would pull back, emotionally pull back from him. That's corroborated, and that will be presented through other witnesses, through the email correspondence between the two of them. That further bolsters the particularized guarantees of trustworthiness in the statements that Mr. Neuman made to Ms. White. Ms. White is recounting what Mr. Neuman told her, and Mr. Neuman is recounting what we can establish in large part through other evidence. It's not as full a picture. It's not as probative on the point as this evidence is, but we do certainly have much other information that corroborates what Mr. Neuman told Ms. White. I'll make one other point because I anticipate it will be a point that is addressed and brought to the court's attention by the defense. I was handed this, I walked in the defense response, so I haven't read through it or gone through it yet, but I will as the defense argues. I anticipate that they will say, well, nothing Mr. Neuman says can be reliable because the jury found him guilty but mentally ill, and nothing that Mr. Neuman says is reliable is because there was testimony at his previous trial that he was delusional. State's response to that is there was also testimony at his previous trial that he was malingering, that he was faking a mental illness, and that there was nothing wrong with Mr. Neuman. The jury came back with a verdict of guilty but mentally ill, and the state accepts that that's what that verdict was. That, however, for two reasons, doesn't undermine the state's position that his statements to Melanie White should still come in because they're still material probative and reach the level of a particularized guarantees of trustworthiness. First of all, anyone who is there was dispute over what, if any, mental illness that Mr. Neuman had, but the state's position is as a category, even if the man was mentally ill, there is no exclusion from mentally ill people. Certainly Mr. Neuman, all the testimony at trial and all the evidence I expect to be before this jury would be that Mr. Neuman was a rational human being, he conducted his life accordingly, that everyone who had day-to-day contact with him relied upon what he said. He was employed, he's had a job, he performed exceptionally well, and there wasn't anyone around him who doubted his veracity, who doubted the things that he said, that there wasn't anything about his day-to-day living that would render him or someone like him as a category, someone who should not be relied upon to convey the truth to friends, colleagues, and individuals around him. So there isn't anything about Mr. Neuman, the description of his day-to-day life that would render any statement he said as a category unreliable. Secondly,
Just ask you that.
Yes, sir.
Well, but if he was delusional, and he quote unquote may have been making some of this up, why should I allow this information to go before a jury?
What I'm arguing to the court is that there was no finding by that jury that he was delusional. There was no specific finding that he was. In fact, had they found him to be suffering from delusions, the verdict would have been not guilty by reason of insanity and not guilty but mentally ill. There was no specific finding by the jury about what, if any, mental illness he had, and the specific mental illness he had was very much in dispute, if at all. If he indeed had one, there was testimony he was malingering. It was very much in dispute at that trial. So without a specific finding of the jury, I think that is not a decision this court needs to reach. Second, the state has charged Ms. Sneiderman with perjury. And part of the issue, or material issue, in the trial of Mr. Neuman was whether he was in fact delusional or whether he was just someone who killed the husband of his lover. If the testimony of Mrs. Sneiderman at that trial had been truthful, the state has alleged it was not, had it been truthful, had she acknowledged that there had been a romantic relationship, had she acknowledged the details of the physical relationship because it went to the defendant, Mr. Newman's motive, because it went to whether he was suffering from delusions, whether they had a delusional relationship, he imagined it, or whether there was a real relationship, that was something that the jury wasn't fully apprised of, the state's allegation is, because of the perjured testimony given by Ms. Sneiderman. So I think even the guilty but mentally ill determination by the jury is somewhat undermined by the fact that they didn't have all the information. The testimony, the perjured testimony of Ms. Sneiderman contributed to what we think was a verdict too lenient and gave Mr. Neuman too much of the benefit of the doubt. Because she lied about the relationship, the jury returned a verdict that they shouldn't have returned. It should have been straight up guilty, and it very well could have been, because she denied the details of the relationship and made it appear as though he was delusional, when in fact those facts had happened and they actually did have a relationship. So as it relates to Mr. Newman's mental state, the state's position is that while certainly that was the finding of the jury, it's undermined for two reasons. One, it was in dispute. There was no specific finding that the man was delusional. And in fact, if the jury had found he was delusional, he would have been found not guilty by reason of insanity. And second, even the determination that he was mentally ill was, I think, the state's position, because we charged her with perjury, was contaminated by the perjured testimony of Ms. Sneiderman. She contributed to it. She contributed to that finding, and now she's seeking to benefit from it, and the state asked the court not to let that happen, that we'd ask that Mr. Newman's statements, as he relayed them to Melanie White about the relationship he had with Ms. Sneiderman, that be permitted under the residual exception, Rule 807.
Thank you.
Thank you.
Mr. Morgan, was there any question there?
Your Honor, may I approach?
You may.
Your Honor, contained herein is a brief with the exhibits that we just provided to the state on this issue, Judge.
Thank you.
All the cases that I will cite are included in that brief, Judge. However, one of the cases that the state just provided to us, I would like to make a note. In Miller v. State, Supreme Court of Georgia 283, Georgia 412, this is a case that one of the cases the state relied on. It says a trial court does not abuse its discretion when it admits under the necessity exception hearsay testimony consisting of uncontradicted statements. Judge, we contradict these statements up and down and all around. Judge, there's under the new rule 807, that is the residual exception to the hearsay. First of all, the state has admitted that they cannot go under any of the firmly rooted exceptions to hearsay, and therefore they're relying on 807. To begin with, the preamble to the new evidence code, Judge, says that courts should look to the federal cases and determine how to determine the new rules. And the state has cited many of the cases under our old necessity exception. We've included some of those, but we've also looked to the 11th Circuit and the Supreme Court as well to interpret the new residual exception. First of all, Judge, the 11th Circuit has made it clear that the residual exception should be used only in the rarest of circumstances. It's not a catch-all to bring in everything that the state or either party wants to bring in. The state has three burdens, Judge. They have three tests they must overcome, and they cannot do any of the three. The first one is under Rule 807, which is called the circumstantial guarantees of trustworthiness. That applies in both civil and criminal cases. 807 is not limited to just criminal, it's not limited to civil. It is an evidence code exception that applies to both. The state cannot meet that burden, which I will show in just a few minutes. But Judge, this case has a higher degree of burden under the United States Supreme Court when it looks at the residual exception 807, because we deal with a defendant who is being charged and she's entitled to the Sixth Amendment Confrontation Clause. And so the courts have said there you must use a particularized guarantee of trustworthiness, a higher standard than just as applied in 807. And then finally the court must determine, after looking at these two tests, whether or not the probative value actually outweighs the prejudicial impact to our client. First of all, Judge, let's go back to the first test, 807, circumstantial guarantees of trustworthiness. One of the things that the court must look at is the relationship between the out-of-court declarant, Mr. Neuman, and the in-court testifier, which will be Ms. White. Judge, he was a client of hers. She was a real estate agent. It's not, when you look at all the cases over and over again, familial, husband, wife, parent, child, or best friends. By her own testimony, Judge, she says, and this is from the discovery provided by the state to us in a recorded conversation, she says, this is Ms. White talking about their relationship. Hemy was trying to find a job. Rusty was trying to find a business to purchase. I'm in real estate. I know a lot of business people. I try to make a commission anywhere I can, so I was trying to put him together, Rusty together, and he met or spoke with a couple of my clients as to whether or not they would or not be a good fit for business. That was it. She went on to tell the police, quite honestly, I didn't want to hear it anymore. I was just kind of tired of it because it wasn't business. Judge, this was a business relationship. It was not a confidential relationship. No offense to my friends who are realtors, but I cannot imagine a real estate agent calling up a client and say, I've got a great house for you, 10% down, Fannie Mae back mortgage, and tell me about your sex life. It's not the type of relationship that would breed confidences. And before the court can enter into even looking at it, you must look at the relationship. And the relationship between these two people do not even pass it. But secondly, the state cannot ignore the fact, one of the tests the court must look at is the character of the out-of-court declarant. Now, in all the cases that I'm sure the state has cited, because we've looked at them very carefully, there was no question as to the character of the out-of-court declarant. In this case, there's a lot of questions as to his character and his mental stability. Your Honor, this court can take judicial notice that in the previous trial, psychiatrists testified that Mr. Neuman said that he had heard demons ever since 1981. That psychiatrists testified that Mr. Neuman said that he wasn't sure whether the sexual relationship with Ms. Sneiderman was real or was it imaginary. The court can take judicial notice that psychiatrists testified that Mr. Neuman said that he had been hearing demons and angels, and that an angel came to him in the voice of Olivia Newton-John, and a demon came to him in the voice of Barry White and told him to kill Rusty Sneiderman because he, Mr. Neuman, was the father of the children. Your Honor, the court can take judicial notice that a jury found that Mr. Neuman is guilty but mentally ill. Your Honor, Mr. Newman's character is this. He is a certifiable, judicially determined lunatic. It is not the type of character that comes in this residual section to 807, Judge. The relationship doesn't make it, as well as the character of Mr. Neuman doesn't make it. But let's move on to the next.
Before you move on out of that last comment, but I'll always have a little bit of magnitude. But now he was found guilty of mentally ill. You're saying that's equivalent to being a lunatic, Mr. Moore?
I'm saying his statements themselves show he's a lunatic. His admissions to his psychiatrist. I'm not a psychiatrist. I'm just an everyday person. But those statements do not come from someone who is rational enough that this court should say that there's inherent trustworthiness to his statements. Because this court must find that the statements are so inherently trustworthy that they should be allowed in. In fact, but the Supreme Court under Idaho versus Wright has gone even further under the residual section, Judge, because there it says when the confrontational clause kicks in, we're beyond the circumstantial guarantees of trustworthiness. We're now into particularized guarantees of trustworthiness because the Sixth Amendment provides the defendant the right to cross-examine the witnesses against her. And in fact, what the U.S. Supreme Court has said in Wright is that the court must find that the statements are so inherently reliable that there's marginal use of cross-examination. If these statements come in, we certainly would like the chance to cross-examine Mr. Neuman about those statements. Again, Court, the U.S. Supreme Court has said that before you let in statements under the residual exception, because it's not a firmly rooted exception, when the confrontation clause kicks in, the court must find that the statements are so inherently believable, well, they use the word trustworthy, that it would provide little or marginal use of cross-examination. That is not the case here. The other thing in Idaho versus Wright, Judge, that is very important, that the state in its argument and the state in its own brief has what we call bootstrapped, trying to show the reliability of these statements. Idaho versus Wright, again, on the residual exception, is very clear. When the prosecution is trying to get in statements, the court must look to the four corners of the statement and cannot take in outside extrinsic evidence. That's directly from the U.S. Supreme Court. On the other hand, because of the confrontation clause, the defense can look outside the four corners and attack and look at the credibility of the out-of-court declarant. Again, the credibility of the out-of-court declarant here, Mr. Neuman, certainly is very, very questionable. His statements, his out-of-court statements, should not be admitted. And finally, Judge, the probative value of this does not weigh the incredible prejudicial impact. The problem is Mr. Neuman made many different statements to different people regarding this alleged relationship. Oh, and by the way, Judge, I thought it was interesting. We cited in our brief Carr versus State, as a Georgia Supreme Court case. It said, when looking at the necessity exception, Judge, the court must pay really close attention to statements regarding an adulterous relationship because the out-of-court declarant has a motive to exaggerate or to lie. That's straight from the Georgia Supreme Court. So when you are asking a witness to testify about what somebody told them about an extramarital affair, the courts are very, very reluctant at letting those types of statements in because, Judge, of the prejudicial impact. And like I said, we don't get the chance to cross-examine Mr. Neuman about these alleged statements. The statements that he said, maybe I had sex, maybe I didn't. He told some employees, yes, he was having an affair, but it was not with a GE employee. Judge, he's been all over. This court must find that those statements are inherently trustworthy and reliable before they come in. And we said the state has not even come close, in meeting that burden. Thank you.
Thank you. Ms. Carl,
Just very briefly, Your Honor. The defense wants to talk about the relationship between Ms. White and Mr. Neumann. Well, Ms. White, we proffer as a testimony at trial. She'll be here. They can cross-examine Ms. White about the relationship we have with the defendant Neumann, and I expect her testimony would be exactly the same as it was in the first trial, that he considered her to be one of his best friends, that they were confidants, that he confided in her about his relationship. They started out several years before the summer of 2010 as a realtor and someone who didn't have frequent contact with each other beyond casual social acquaintances. But it was during this time period that they got much closer and that he confided in her regularly, and that would be the testimony of Ms. White. So the defense is free to cross-examine her about that. She'll be here. And any details of the relationship that they feel are deficient would go to the weight of the evidence and not its admissibility in general. Secondly, the character of the declarant, the defense argues, is lacking, and the court, I think, took notice of the statement I took notice of, that he is certifiably, judicially certified to be a lunatic, something like that. I think that is beyond anything that would be supported by the record in front of the court or the testimony that was at trial. He was not a certifiable lunatic. The man, as we discussed before, lived day to day. The people around him didn't notice anything about him. No one ever found him delusional, and he was only reporting these delusions at some time after he was arrested for murder and setting up what we believe was a fabricated or at least an exaggerated mental health defense. So it's not the statements that he gave after he was arrested that the state is intending to give in, but one that he confided in and divulged information he divulged to a close confidant at the time he was going through a difficult period. It is corroborated in many respects. There's no reason to doubt the testimony that Ms. White would give about the statements Mr. Neuman provided to her.
Well, let me ask you though,
Yes, sir.
In light of the fact that the jury found him guilty with mentally ill, am I not to give that any weight that he may have been mentally ill at the time he was having this conversation with Ms. White?
I wouldn't submit to the court that you give it no weight at all. I'm saying that it is not dispositive one way or the other. For all the other reasons that the state has described, it does meet the materiality portion. It is probative on this point. And it does, in the particulars that we're offering to the court, it does satisfy a particularized and circumstantial, or particularized guarantee of trustworthiness. In that it is corroborated in several respects. Mr. Neuman, for example, Mr. Neuman told Ms. White that when the two of them traveled, Ms. Sneiderman and himself, that they got adjoining rooms so they could be together at some portions through the night. That will be corroborated at trial with the testimony in the hotel records that they did in fact have adjoining rooms when they stayed together, and that his statements to her in that way were corroborated. I'd also say too that in Carr versus State, the case that Mr. Morgan brought out, my recollection, and I don't have it in front of me, but my recollection is that the discussion about whether statements about an adulterous relationship would meet this particularized guarantees of trustworthiness, it was when the individual who was having the affair was talking to the person she was having the affair with and describing the state of her marital relationship. So it is that situation that the Supreme Court said that is less than trustworthy, that there is an obvious motive for someone who is in an extramarital relationship to exaggerate or to fabricate it or position him or herself in a way relative to the marital relationship that is untrustworthy. I mean, to put it more colloquially, it is not uncommon for someone to lie to their lover about how bad their husband is. That's the situation that was in Carr. And that's not the situation we have here. It's not statements that Mr. Neuman made to his wife, who he was having an extramarital affair outside their relationship, having a relationship outside their marriage. It is statements he made to a confidant of his. He had a reason to lie to his wife. He didn't have any reason to lie to his wife. She was his friend and she was helping him. There was no reason to lie to her. And that's what distinguishes Carr. And that is one of the reasons. He was honestly seeking help with a friend who was a confidant. And that rises the statements to the level of particularized guarantees of trustworthiness.
Also, Ms. Cross, I know
Yes,
this motion was filed relatively late in the process. In this case, it's been specially set for some time. And to select the jury on Monday, I believe this motion was filed when?
Earlier this week, it was Monday this week, Your Honor.
And when did the state first find out that Mr. Newman would not be available?
We had been in discussions we had spoken to his attorneys several times, and it was late last week that I had the discussion with Mr. Rubin, who still represents Mr. I'm sorry, it might be as many as 10 days ago. That had the discussion with Mr. Rubin and then confirmation with Mr. Clegg that Mr. Neuman would in fact be unavailable for this trial due to his invocation of privilege.
You know, because obviously we're having this motion to relatively late and close to proximity of the action.
I understand that.
Because always though, regarding several hundred jurors who feel like questionnaires inside this trial on Monday.
Yes, sir.
They put in your position, I have to schedule this hearing at 3 o'clock this afternoon so that we can have at least the arguments prior to Monday. But, all right.
Thank you, Your Honor.
No, thank you. Anything else on that issue? I'm going to take this matter under advisement. I will give you some direction prior to opening statements. That's about the best I'm going to do. Anything else on that issue?
No, sir.
All right. Who's the next motion? You want to do yours now? Mr.
Well,
Clegg?
can we approach her?
Sure. Come on, boys. right, Kelly, we're back on the record. Mr. James?
Yes, sir. At this point, the state would make a motion, and I think I started to do so earlier. I'll follow through with it at this point. Make a motion to authorize counts 1, 2, and 3 of the indictment.
Mr. James, the way it's listed, count 1 is malice murder, count 2 is felony murder. You say count 3 is aggravated assault.
That is accurate, Judge.
Go ahead.
As is customary, and I believe as is also required, I would tender a reason to make this motion to nullify the counts. The court's aware that there are jurors that have been called in, and we will be striking a jury if there's no resolution on Monday morning, and so I won't be too detailed in terms of the evidence because I do not think that that would be appropriate. However, what I will state is that on June 28th, we received the first batch of discovery being evidence that the defense plans to present at trial. On July 15th, we received the second batch of discovery, that is evidence that the defense plans to present at trial. And as late as this morning, we've been receiving discovery from the defense. I will tell you that after receiving the first batch of discovery, we started examining, quite frankly, some of the evidence that we had planned to present in our case as it pertained to counts 1, 2, and 3. After we received the second batch of discovery, we, the state, went back and we re-interviewed most, if not all, of our witnesses in this case. There was specifically the because they were my concerns as it pertained to ethical obligation not to seek convictions but to seek justice. And I believe that it would be unjust and unethical for the DA's office, for the state, for the district attorney of this county to go forward on a charge that I am not 100% someone is guilty of. I am by no stretch of the imagination making a public statement exonerating one, but what I am 1, 2, and because it's time for the state to make a motion and authorize these counts, and we are ready to proceed on counts 4 through 13. I'm sorry, 4 through 16. Thank you, Judge.
And I had asked earlier, and I heard from the
subjects, but there is no smoking gun in there, which would lead anyone to conclude, wow, looking at this, all of a sudden I can say they don't have a murder case. I believe they have known all along they didn't have a murder case. Be that as it may, I welcome at this time Mr. James's admission that he does not have the degree of certainty necessary to go forward with a prosecution for these counts. So I have no objection to the dismissal of counts 1, 2, and 3, the murder, felony murder, and aggravated assault.
Well, Mr. Clegg, before you take your seat, obviously the court has some say in this.
I understand that, sir.
And no one's presented to me a case that says the court must accept the state's motion, basically 72 hours before we select a jury, to dismiss the malice murder count, felony murder count, and aggravated assault count. Is that correct?
Your Honor, you are absolutely correct. There is no legal requirement that the elected attorney is ethical going those 3 counts. In light of that, I don't see, I mean, are you obligated to do it? Do you have to do it? No, you do not. In the interest of justice, is it should do.
Yes.
Okay. That's my position. That would be an interesting situation in the trial when, lo and behold, the jury is advised that there are 3 charges. I'm happy to respond to whatever questions you might have, but just to emphasize and re-emphasize, we have absolutely no objection to the state's motion.
Mr. James? Yes, sir, Mr. Dean.
Trying to express this the right way, Your Honor, but I feel like that was a cheap shot. I've been spending the last month and a half with Mr. Clegg and Mr. Petrie in and out of my office since the beginning of June. all right, asking me, look at the case again, look at the case again, look at the case again. They know, all right, and I'm not going to get, because we haven't tried the case, they know that there are certain pieces of evidence, because this case, our case was a circumstantial evidence case, and there was never any, it's not a big shock, no big surprise about it. It wouldn't be the first circumstantial, it would not be the first.
Lawyer, let me do it this way, lawyers. First off, I'm here from everybody. Let me do it this way. Lawyers approach. Don't let anybody finish.
Okay,
Come on,
maybe
come on,
I apologize.
Come on, lawyer.
Yes, sir, sorry.
Let me make sure we're on the same page.